and welcome back to the show. For largely more than a decade, decisions that have been handed down by the United States Supreme Court were largely in step with the American public opinion on major policy issues as the court's makeup grew more conservative. Now, abruptly, that's no longer the case. The court's decision in Dobbs versus Jackson has garnered all the recent attention by reversing a 50-year precedent and eliminating the constitutional right to an abortion, despite the fact that a majority of Americans support abortion rights. It's better known as the recalling of Roe versus, or the overturning, I should say, of Roe versus Wade. And here now joining us to share a little bit more about that and then some, we've got the founding partner at the Boyd Law Group, Patrick J. Boyd. And Patrick, glad to have you with us.
My pleasure to be here.
Well, let's talk a little bit about this here. First of all, let's just go on the basis of what we've seen happen. A lot of people were surprised because it seemed to be leaked out for the first time, something from the Supreme Court, that Roe v. Wade would be overturned, and it happened. And yet and still, a lot of surprise and a lot of backlash from you from the legal perspective. What's it been like for you in hearing and talking and dealing with this Roe v. Wade decision, the overturning?
Sure. Well, I mean, the first thing, which is interesting and surprising and unique, which you mentioned for us as lawyers, is just the fact that there was this leak, right? The Supreme Court is hallowed chambers of our justice system with magnificent minds working on the finest of legal precedents and hoping to collaborate in their work confidentially, because quite frankly, as you're working to develop an opinion, you may change your opinion from time to time. And in this case, instead of that freedom of exchange of information happening without a leak, we got a leak of a decision, which scared a lot of people that Roe would be overturned. And I think after the leak, there was a lot of sentiment that perhaps it was just a drafted opinion in process, and perhaps the opinion would change, and there would be perhaps it was partially hopes and partially expectations that the actual final opinion would be different. But sure enough, the final opinion was issued and seemed to be very much consistent with that earlier draft that we saw, and overturned more than 50 years of precedent, which acknowledged the constitutional right to an abortion. So an insight into the politics and the way the court works that is somewhat disappointing, I suppose. And then obviously a groundbreaking decision for the court as well.
Correct me if I'm wrong. This is a decision that really started. People ask, where did this whole overturning start? And from what I understand, it was a local case in Mississippi.
That's right. The state of Mississippi, presumably with the understanding, and different states have been passing legislation that's been overturned or overruled by courts for quite some time, right? In other ways impacting abortion rights, requiring parental consent, for example, or having a waiting period mandated, or these kind of other things. This Mississippi law was implementing a further restriction on a right to choose. So Roe v. Wade upholds the second trimester, the end of the second trimester, as that fundamental constitutional right for an abortion. Mississippi was trying to roll back that timeline to 15 weeks, and that was the law at issue and brought to the court. The interesting part, or at least with the decision as well, is that the court really would have had three options. They could have stuck to precedent and said this Mississippi ruling is restricting the constitutional right to an abortion. 15 weeks is not enough time, and thrown it out on that basis. That would have just been sticking with 50 years precedent. They could have then also gone with the option that was championed by Chief Justice Roberts, but not endorsed, which is to say, well, we're going to restrict abortion rights a bit further, and we're going to honor this Mississippi 15 weeks, right? So a shorter amount of time for women to have the right to choose in Mississippi. But the court didn't choose to do either of those. Instead, the court decided to say, we reject the notion under the Constitution of these United States that there is a fundamental right to choose, and we're going to throw out Roe v. Wade in full, which theoretically sets up the scenario where certain states could decide to pass laws restricting abortion rights at day one.
So for New Yorkers, and particularly New York women, give me a little insight as to how this is actually going to affect New York women. What does this actually mean?
Well, the good part of the structure of our government, and the part that the court was really talking about, was the notion that different states and elected officials in different states can make the laws that they wish to make to support the citizens of their states. And so in New York, as with multiple other states, even in anticipation of this ruling, there was a decision to uphold the right to choose, the right to have an abortion, and indeed funding set up to make sure that women in states where they might lose that right can be allowed to come to New York as a place to recognize that right to choose if they're not allowed to in their home state. And I think the governor funded certainly millions, I think something like $30 million to make sure that right was championed here in New York, and that women, 35 million was set aside to make sure that there was a fund to provide for the influx of patients who wanted to have abortions and couldn't potentially in their home state, and security grants also for the clinics, that is the clinics that were going to be administering the abortions, to make sure that they felt comfortable continuing to provide that service to women. And that's consistent, at least, with the general citizenship of the state of New York. The right to choose has been consistently advocated for and endorsed in the state. So the governor was doing what her citizens wanted her to do, presumably, in doing that. And that's happened in, at this point, probably close to half of the states of these United States. Some trigger law went into effect, allowing to making sure that though the Constitution does not insist upon the right to choose, individual states will allow for that right to choose. So women in those states are not really in much different of a position than they were preceding the ruling of the court.
How much do you anticipate litigation coming on this part from New York, given the fact that New York has taken a strong opposite to what the overturning of Roe v. Wade, saying that we would be, quote unquote, a sanctuary city, a safe state for women? How much can we expect litigation to come from both inside and outside?
Well, I think in New York proper, because there at least appears to be such a political lean to the left on this particular right, at least, that is the right to choose. I think most of the funds and work is going to be put into place just to make sure that that right to choose is exercised, supported, and that money is spent to make sure we provide the safe right to choose for women in the state and women coming from outside of the state. The very interesting trend as to litigation and quite frankly, the operation of government is what's happening in other states. And just as an example, yesterday on the ballot in Kansas was a law that would have allowed the legislators to pass regulations restricting a woman's right to choose. Kansas is considered, at least by some, to be a very conservative state. So the thought was that legislation would have traction, and that state would, as a result, pass some meaningful restrictions on the right to choose. And notwithstanding that anticipation, if you will, it was on the ballot. I think just this morning we received some pretty significant feedback that ballot measure lost. That is, that the citizens of the state of Kansas came forward and voted pretty substantially and significantly, and somewhat surprisingly to some, to continue to allow the right to choose to exist in Kansas, and not to give the legislators power to meaningfully restrict the right to abortion in that state. So I think there'll be a lot of those legislative initiatives, if you will, in different states, and certainly some froth in the political process as a result, as different states and different citizens vote on how they feel on this subject.
Yeah, I want to take time and move from one subject to another for a second. We want to talk about Kennedy versus Bremerton, and for people who aren't familiar, this is particularly that deals with prayer in schools. A ruling was made with regards to prayer in schools, where prayer is allowed in schools. Now, while this ruling has come forward, there's still a lot of questions as to how this is all going to play out and what this actually means in terms of legality in certain areas. And so correct me if I'm wrong, it's a little gray here in Kennedy versus Bremerton. There's a decision that's been made, but I think on the wider scope, a lot of people are still waiting to see how this plays out.
Yeah, I think that's true, and it's a fascinating trend that's been happening for some time now. Honestly, as the court has gotten more and more conservative, right now we have a 6-3 conservative court. There have been a flurry of decisions taking further steps to endorse and somewhat support the possibility of religious expression and prayer. In Bremerton, there was a high school coach. He was I believe, a former military member and a person who found religion significantly helping him in his early years right after high school. He became a coach and found that being a coach for students was very much his calling, something he was very grateful for. As a result of that, he would, during the course of football games, particularly at the end of games, go to the 50-yard line and take a knee in thanks for the opportunity to coach the young men. Not necessarily if they won or lost, by the way, but just in thanks of the opportunity to do what he was doing with the students. The funny part is that apparently he was doing that for several years without anything coming up. Nobody regulated it. Nobody chose to do anything. And at one point in time, a couple of years later, a competing team came out and saw this prayer, and the coach from that team called this coach's school and said, "What a great thing! I didn't realize that we could pray on the field." And some of my players came out there and prayed as well. At which point the school found out and got very concerned and started to try to restrict Mr. Bremerton's right to pray. He filed a claim as a result. The school was trying to restrict his constitutional rights, and the court was challenged with the notion of determining whether or not allowing prayer in a public school, right, constituted the government's endorsement of that prayer. That is, if the public school is allowing people to pray, does that mean the public school is endorsing prayer and endorsing faith, and as a result, bridging constitutional rights of people who don't have that same faith or don't have faith at all, if you will. And so what the court said was, in this particular case, at the end of an extracurricular activity, where the participation in prayer is purely voluntary, kids were not, students and players were not required to pray. They were not assigned to pray. They were not punished if they didn't pray. But at this extracurricular activity, after its conclusion, if that coach chose to pray and other people chose to pray, then the government should not restrict that ability to pray. That ability to pray is a fundamental constitutional right that should be endorsed by the court. So it's a very complicated decision in the sense that decisions are different if that prayer happens within the school. Certainly decisions are different if people are required to participate in the prayer. But it is going to be an interesting interplay as to where religion finds itself in public schools these days. And this decision has raised a lot of eyebrows and changed some things.
Yeah. And so as we talk about raising eyebrows, a lot of eyebrows were raised by this decision, but there's still a lot of gray in terms of that. So walk us through a little bit more about the gray and how this is going to actually play out in schools across perhaps the tri-state area.
Yeah, I think it's really going to depend fundamentally upon each instance, right? Is the leader, the teacher, the coach forcing or encouraging in an unpleasant or unfair way the students or the makeup of the school to engage in prayer? If that's happening, then the government is establishing religion, and that's prohibited. If the coach or the student or the teacher is voluntarily engaging in prayer, not choosing to enlist anybody else, and engaging in prayer is not making it appear that the school, which must be neutral and is government funded, right? If they're not making it seem like the school supports the prayer, then arguably that right to prayer should be recognized and embraced, or at least left alone. You should be allowed to have your quiet prayer meditation. At this point, you certainly can't be prohibited from giving thanks when you open your lunch bag, right? Right. Even in school. And now we know that you can't be forbidden from taking a knee at the end of a football game. But when in other places you can pray and not pray, and with whom you can pray and who you can encourage to pray or not, these are complicated things. Some of the objectors made a fair point. You know, if this coach is engaging in prayer and players feel that they better pray with him, or they're not going to get a chance to be the starting quarterback or wide receiver, perhaps that is a risk that was being run. But the court felt that the importance of allowing prayer was greater than that risk in this particular case. But I think you're right. I think there are going to be a lot of individual cases where the facts and circumstances are going to be scrutinized, and we'll have some more decisions to talk about.
Yeah. Talk about decisions. I want to take time to talk a little bit about employment, some arbitration cases that you're taking a look at, and some employment cases that we're taking a look at nationwide that have also local impact. Give us a couple.
Yeah, so two of the decisions that have come out and had some meaningful impact are decisions that relate. I'll start with the arbitration decision first. As people may know, this is the Morgan case. As people may know, a lot of employees sit down and they don't even know what they're signing, but when they start work, they sign a document that mandates that if they have a dispute with their employer, they must arbitrate that dispute. In the Morgan case, the issue was that the employer had fought the employee for quite some time without compelling arbitration. That is, they had not forced the employee to arbitrate the case right away. And the question was, well, can the employer just wait forever and still have a right to arbitrate the case? That is, can you fight with your employee for a while, and then all of a sudden can they say, wait a second, Patrick, there's an arbitration clause, you have to arbitrate? And what the court said is, no, the employer doesn't have the right to sit forever waiting to enforce their arbitration agreement. If they want to mandate private non-jury arbitration, they have to act quickly, or they're going to lose that opportunity. And this is, Daren, a meaningful erosion of something that a lot of employment lawyers, maybe a lot of lawyers overall, don't love. We operate in this country with the embrace and the understanding that a jury right is a fundamental right. And the idea that jury right can be removed by arbitration provisions where you just get one paid person and a private arbitration is not something a lot of people love. And the courts are slowly but surely eroding that mandated arbitration, making employment disputes a little bit more public, a little bit more open. And I think a lot of people think that's a good thing.
So for us, when we take a look at these cases, I think for the average person, they say, how does this actually impact me? How long does it take from the time a decision is made to actually seeing it boots on the ground?
That's a great question without an easy answer, right? I think it depends. It depends on the court. It depends on the case. It depends on the framework. I think that the thing that a listener can think about and embrace, I hope embrace, is that employment law is changing. It is changing predominantly in favor of added rights for employees, added public opportunities to voice their grievances, and added rights to collectively bargain, like in the unions that you see forming in Amazon and Starbucks. So worker rights are getting to be greater. The Great Resignation is demonstrative of the fact that people are expecting that to happen, or they're not going to stay at their jobs. And overall, I hope that's going to lead to a trend of people having better selective processes in choosing the job they want, and better rights if the job they want is not fair to them.
Yeah. Well, Patrick, we got to leave it there. I want to thank you so much for taking the time and joining us and sharing about these cases: Roe versus Wade, prayer in school, arbitration, employment, things that are all germane to what a lot of people are dealing with right now. Of course, we got to bring you back so that we continue to discuss this a little bit more and break some more things down in depth. Patrick Boyd, our guest, and Patrick, thank you.
My pleasure.
All righty. Well, I want you to stay tuned because guess what? We have more Social Justice Forum continuing. Don't go anywhere. We're coming back right after this.